Good morning, everyone. Welcome to our webinar this morning on planning for the future, making a will. I know we still have some people joining us, so I'll just do some introductions at the beginning while everyone's still kind of logging on. So my name is Jessica Steingard, and I am a staff lawyer here at the Center for Public Legal Education Alberta, or CPLEA for short. And our goal is quite simple, and that is to make the law understandable for Albertans. So we are a nonprofit organization. We serve all of Alberta, and we provide legal information and education through our various booklets, info sheets, websites, FAQs, videos, webinars like this one, and more. And all of our information is freely available to the public. This is part one in actually a this is part two in a 4-part series we are doing. 2 weeks ago, we discussed mental capacity. That recording is actually available on our YouTube channel, and we'll post the link for that in our chat. So if you wanted to learn more about mental capacity or decision-making capacity, you can check out the recording of that webinar. In the next 2 sessions after today, we'll be covering powers of attorney and personal directives, and we'll be concluding this series at the beginning of March with a session on the Adult Guardianship and Trusteeship Act. So just to kind of situate where we are in this series. Before we go on, I do wish to acknowledge the traditional homeland of the many diverse First Nations, Métis, and Inuit people whose elders have walked this land before us, and those persons with whom we share this great land today. So I'm here in Edmonton in Treaty 6, but we know that people are joining us from across the province and even beyond. So quick disclaimer this morning, our presentation this morning contains legal information. It is not intended to be legal advice. When we get to the Q&A session at the end of the webinar, we'll make sure that we leave some time for questions. Just a note that we are happy to provide more legal information, but we unfortunately cannot give any legal advice during this webinar. We'd also like to acknowledge the generous funding provided by the Alberta Law Foundation and the Department of Justice Canada that make presentations like this one possible. A few other housekeeping items before we go on. We are recording today's presentation. I mentioned that we had already posted a series on our YouTube channel, and we'll be doing the same with today's. So if you want to watch it back later or know someone who would like to watch it later, just check out our YouTube channel within a few days. And as I mentioned, we like to save questions till the end. Please put your questions in the Q&A function. You'll see the little block there you can put your questions in. Feel free to put them in throughout the presentation, but we will save them for the end, and we'll hopefully leave about 10 minutes to do so. Okay, housekeeping's over with. Where do we want to go today? So we have a bit of a 2-part presentation this morning. We're going to start today's presentation with a bit of an overview of making a will. So I've called it Making a Will Basics, kind of the who, what, when, where, why of wills. And then we're going to move into a panel discussion. So you'll see kind of 2 boxes on your screen, Amy and Adil. They are here with us this morning to share a little bit more about wills. So we will be having a good discussion for about half of the presentation today. Before we jump into the meat though, I just want to get a quick sense of who's on the line with us this morning. So you're going to see some questions pop up on your screen. If you could take 30 seconds to answer those, that would be great. And I think there's one more question. So good to know we've got some familiarity, not a lot of familiarity with making a will. So we've got lots of room for learning today, hopefully. And I think there's one more question. There we go. Perfect. And it looks like we've also got lots of people that are not necessarily familiar with our resources. So hopefully we could share a little bit about those today, and you can take those with you virtually, of course. Okay, let's get into the meat of today's topic. So a will, we're here to talk about wills. So a will is a legal statement of how you want your estate to be dealt with after your death. And the person making the will is called a testator. Now let's break that down a little bit. Let's look at, so kind of different components of this definition. First of all, it's a legal statement. So we're going to be looking a little bit about what we need to do to make it a legal statement. It talks about your estate, so what is included in your estate. And most importantly, it talks about what happens after your death. So sometimes a will is confused with other documents that can help you make decisions while you're still alive, namely personal directive or power of attorney. So signing a will does not mean that it comes into effect right when you sign it. It only comes into effect after you pass away. So it really only deals with things after your death. So let's start with some of that legal statement part of the definition. So what makes a will a legal document? Well, the first part of that is who can make a will. So the legislation in Alberta says that anyone can make a will who is 18 years or older. There are a few exceptions to that 18 plus rule. If you're under 18, you can make a will if you have a spouse or an adult interdependent partner, if you are a member on active service with the Canadian Armed Forces, or if you have the court's permission to do so. The other part of who can make a will is we look for what we call testamentary capacity. So this kind of touches on what we had talked about in our first session on mental capacity or decision-making capacity. We talked a lot about testamentary capacity and being, what you have to be able to understand what you're doing. So there's three different components to this. We look to make sure that you know that you are making a will and you understand what the document is. We also make sure that you know what property you own and that you're aware of the people you would normally provide for. So if your will says, give everything to charity, but you have young children, the question would be, do you understand that, that your children are someone that you would normally provide for and that you're making this request, in spite of that? So that's when you're with a lawyer signing a will, they will look for this testamentary capacity and make sure that you have it before you can actually sign it. If you aren't over 18 or meet these exceptions, and if you don't have testamentary capacity, then your will won't be valid. And so it won't be accepted as a valid will. The other part of that legal statement piece of the definition are the different types of wills that you can make. So in our Wills and Succession Act, it describes three different types of wills. So the first one is a formal will. A formal will means that it is signed by the testator and two witnesses, all in the presence of each other. And that last piece is really important, the all in the presence of each other. You can't have the testator sign and then one witness sign the next day and then the third or second witness sign the day after that. They all must see each other sign the document and be in the room at the same time. So that's crucial. A formal will is the type of will that you would normally get from a lawyer's office. Now, it's not the only place you can get one, but that's if you see a lawyer, that's the type of will you're likely to get from them. There's two other types of wills. So one is a holograph will, and that's a handwritten will. So it must be in the testator's own writing and signed by them, but it doesn't need to be witnessed. Now, holograph wills are legal in Alberta if they meet these requirements, but note that they are not legal in every province across Canada. So if you have property in other provinces that you're trying to deal with in a holograph will, it might cause you some difficulties. And the third type is a military will. So that is one that is made while on active service with the Canadian Forces. So of course, there's very specific circumstances in which that type of will would be created. So now that we know who can make a will and what the types of wills, what goes into a will? Well, there's several components. Usually a will start off by saying that it cancels all your previous wills. So you can make any number of wills in your lifetime, but it's usually good practice if you make a new one to cancel the old one, because if you don't, then they're both in effect, and then there's some confusion as to, if they express different wishes, then which wish goes ahead, and usually it's the most current wish. But if you have an older will that deals with something and the newer will doesn't, then just creates lots of confusion. So a typical starting point of a will is to cancel your previous wills. One of the most important functions of a will is to name a personal representative. And this is the person who will deal with your estate once you're gone. So they are in charge of fulfilling all the wishes set out in your will and dealing with all of your property and whatnot. The law sets out legal duties that these people must follow. So they must, in essence, collect all of your assets, pay all of your debts, distribute the gifts to your beneficiaries. They also have to do things like file taxes on behalf of the estate, etc. So this is a pretty important person, and you definitely want them to understand what your wishes are. We're going to talk a little bit about personal representatives in the discussion later on, but one thing I'll say here is that it's usually best to talk to this person before naming them. You don't really want to surprise someone with the role of a personal representative. Some people will decline if you ask them, but you want to make sure that that person is comfortable performing that role for you. And something you can do in a will as well that's good practice is not name just one person. Now, I don't mean name 3 people to act at the same time. I mean to name alternates. So you'll usually name one, and then if they can't act, then there's a second person, and so on. Another piece of your will is naming beneficiaries. So who gets your stuff when you're gone? There's 2 different types of beneficiaries that you can designate. So a specific beneficiary is someone that you have gifted a specific item to. So if you say, I want my car to go to my daughter, Joe. Okay, that's a specific gift. The residual beneficiaries are who gets kind of what's left over. So you don't even have to name specific beneficiaries. For example, you could just say, I want all of my estate to be divided between these people, and they're considered residual beneficiaries, or beneficiaries of the rest, you could say as well. Another function of a will is if you have minor children, you can name a guardian for them. And so who would take over care and control of your children if you were to pass away. Sometimes wills will describe funeral plans. A little caveat on this: it's not a good idea necessarily to just include your funeral plans in your will. Sometimes wills aren't read right away. Sometimes people don't know where they are, and they aren't found right away. And sometimes it's after the funeral has taken place. So if you do have specific funeral plans, it's a good idea to share them with the people that you are that will be making those plans, and also to let them know where the will is if they're, say, the personal representative, so that they know where they can also find the details of those plans. Finally, you can list other wishes, some other wishes in your will as well, but the above points are really the main points of a will. Okay, let's look at what is an estate. So that was the second part of the definition we had pulled out. So an estate is essentially the property you own at the time of your death. This includes all of your land and possessions. So a house, a car, a bank account, cash in your wallet, your couch, everything that is part of your estate. There are 2 exceptions to this, though. An estate, for the purposes of administering your will, does not include property that you own as joint tenants. So say you own a house with your spouse. The most common way to own that property is as joint tenants. And what that means is that you both own the whole of the thing. And when one of you passes away, we have what's called a right of survivorship, and the other owner becomes the sole owner of that thing. So any property that's held as joint tenants is not considered part of your estate, and so it's not something that your personal representative would be or that needs to be dealt with under your will. The other piece that's not part of your estate is assets with a designated beneficiary. So you might have a life insurance policy where you have designated beneficiary on the application form. That life insurance policy then does not form part of your estate. Why is it important then that we understand what is part of our estate and what's not part of our estate? Well, one, your estate is what your personal representative has to deal with. And so they will want to know, what assets they are dealing with. And the second part of it is that when you apply for a grant of probate, you're only concerned with assets that are part of the estate. And that's in part because probate fees are based on the value of the estate. Now, in Alberta, probate fees are not a percentage of the estate. It's a kind of scheduled amount. So I think the highest probate fee is $525. And I can't remember, I think it's like $150,000 estate plus. That's the amount, but maybe Amy and Adil can confirm that later on. But that's in part why we want to understand what's part of an estate. So we've talked a lot about making a will. So what happens if you don't make a will? Well, if you die without a will, you are considered to die what we call intestate. So there's two issues that pop up with this. The first one is that there's no one appointed to deal with your estate. So one of the things we talked about as an important function of your will is to name a personal representative, and that person knows that it's their job to wrap up your estate when you pass away. If you don't have a will, then there's no one appointed to deal with that. There's also no formal written record of what you wanted done with your estate. So perhaps you're estranged from family members, or, wanted a large portion of your estate to go to charity, for example. If you don't have a written record of what you wanted done, then the law steps in. So the law can deal with both of these issues. When it comes to the first issue of not appointing anyone, our Estate Administration Act here in Alberta has a list of people who can apply to the court for authorization to deal with your estate. And that person is not called a personal representative, they're called an administrator. And the list of people is listed in order of priority. So the first person on the list is the one who has the highest priority, unless they choose not to act and so forth or don't exist, then it would keep going down. As well, when it comes to your beneficiaries and who gets your estate, our Wills and Succession Act also has a list of people who would be beneficiaries of your estate. And it usually starts with your closest family and is based on who's alive. So if you have a spouse, then it would go to them first. So again, if those people on the list is not who you wanted to have your estate, well, if we don't have a written record, then that's who is the default beneficiaries. Okay, so that's our making a will basics. That was a quick intro to wills, but I do want to move on to our panel discussion here because we have some amazing people who are going to share some of their insights on this topic. So first up is Amy Abbott. Amy is a lawyer and partner at Emery Jameson LLP here in Edmonton. She practices primarily in the area of wills and estates, and she advises clients on a range of estate planning and estate administration matters. A portion of her practice is also dedicated to disability law, and she regularly advises clients on guardianship and trusteeship matters, as well as planning for dependent adult children. So thank you, Amy, for joining us. We also have Adil Malik, and Adil practiced primarily in family law, wills and estates, and real estate. He's been practicing in Edmonton since 2019 with Edmonton Law Office, which is in North Edmonton. Outside of law, he spends most of his time getting involved in a number of local community organizations and associations. And he has also shared with us that he is a gamer as well when time permits. So welcome, Adil, and thank you for joining us this morning. So we have, I think, 6 questions we're going to try and get through this morning. So I'm going to just pop right into question 1 and get our discussion going. So what is the role of a lawyer when it comes to wills? And Amy, I'll get you to start us off.
Thanks, Jess, and good morning, everybody. With respect to a lawyer's role in wills, I see it as a really multifaceted role. I think one of the most important things a lawyer can do in assisting with a will and your estate plan is to really walk you through what you need to think about and the important considerations that you need to be taking into account when you draft your will. And so part of that as well is the lawyer can assist you in identifying the information that you need to gather and think about to include in your will. And a lawyer can advise you basically on how those considerations will factor into your will. So for example, if you have perhaps young children that you need to provide for in your will, a lawyer can walk you through what you need to do to plan for that, and the kinds of provisions you would need in your will. A lawyer, I think, really can help you tailor your estate plan to your personal circumstances. Some people think of estates as being a little bit generic, which they're really not, because so much of your will can really depend and does depend on your personal circumstances. So a lawyer can really help you to understand that. And then, of course, the proper drafting and execution of the will, a lawyer plays a really integral role in making sure that your will is drafted clearly in language that isn't ambiguous or likely to give rise to disputes about what you meant. A lawyer can make sure it's drafted so that it's most likely to hold up and give effect to your wishes, and of course be properly executed so there's no issues with validity. And that, I would say that's just the surface, actually, of a lawyer's role when it comes to estate planning.
Adil, did you want to add to that?
Yes, thank you, Amy. Yes, there's a few things. I think Amy covered most of them. One of the issues that do come up when a client comes to a lawyer for a will is sometimes the clients are old, like all in older age group, and then there's capacity issues, right? So a lawyer's job is not to just, hey, a guy needs a will or somebody needs a will, and then okay, get the instructions and fill out a generic will. Their job, as Amy mentioned, is to sit down with the clients, understand their family dynamics, what they have, and what they're looking to accomplish through their will, and then they can draft a will that is it is very specific to their situation, right? So if you have kids, then you make sure that you have named your guardians for your kids. Now another example would be if you have disabled beneficiaries, right? There's very specific ways the state has to be distributed or has to be distributed in the will for disabled beneficiaries. Otherwise, they can lose their benefits to age benefits. So those are very important things. And then, of course, you have to, when you draft a will, you have to make sure that the will is written in a way that is understandable, is very detailed in a sense that, okay, so sometimes people start, okay, this is my beneficiary, this is my executives, everything goes to my wife and then my son, and just an example, but they don't go down there, okay, what if something happens to your son, right? So you have to be more detailed, and that's where the lawyers come in. They can explain to you, hey, why is this important? And other issue is that once you do a will, there's some forms that go with it. An example would be like an NC8, we call it NC8, affidavit of a witness. Now, sometimes people, when they make their own will, they don't have the document with them. And let's say if they pass and the will has to be probated, there's a probate process that goes to the court. That form is required. Now you might have to, what if you cannot find those witnesses, or you have to chase them around the city or different part of the cities? So a lawyer will, if you go to a lawyer will make, he or she will make sure that all of those steps are taken care of, and then your will is as it should be, to make sure it's not only appropriate now, but it's appropriate if you pass away, and then all the legal requirements are there and the documentation is there.
Excellent. Thanks for that perspective. Yeah, just really that the role that a lawyer can provide, that outside perspective and planning process, things that you wouldn't even necessarily think of. The lawyer could say, hey, can you turn your mind to this? And like you said, so that your will is good now, but it represents your wishes down the road. Wills don't need to be updated manually, say, unless they no longer reflect what you want. So sometimes a will, if you draft it, if it's well drafted and it expresses your intentions, it can last a number of years. Correct? It doesn't, it can. So
yeah, that's right. And just to add to that a little bit, something you both touched on around lawyer, I've been in situations where I ask the client, heaven forbid something happens to all the people you've named in your will. In that worst case scenario, who would you want to receive everything? And a lot of people will go, I never thought about that. And so sometimes just having that, as you say, outside perspective to identify those kinds of, we call them contingencies, your plan A, B, and even sometimes C, to make sure that you have your bases covered. And as you say, Jess, that also reduces the extent to which you might have to revise your will later on if you've laid out that plan, taking all those things into account.
perfect. Okay, I'm going to move on to the next question. You'll see some of these things will kind of thread through, the information will thread through, but I'm going to hop to number 2. So why is it so important for people to make a will, and what happens if they do not? Now, we've briefly mentioned dying intestate, but perhaps you can elaborate on this and share some of the other important parts of making a will. And Adil, we'll start with you.
Yes. So the main purpose of a will is to give you instructions. You are giving instructions to your executors or personal representatives in the future, right? So you yourself will not be there, but this is a document saying this is how I want my state to be divided, and this is how things need to be done. And so that's how you approach this document, right? The importance of the will is this: you can name people that you trust. I mean, let's say your family members and your children. Sometimes it's not true that you equally want all of them to be responsible for some of these jobs, like executors, or maybe you probably don't want some persons to get some item, or maybe one of you're estranged to one of your children, or so there's some issues that you don't want them to get part of your estate. Then that's where the will comes in, because you can give very specific instructions on who gets what, and in what form, and who is going to be the executor. So sometimes I have clients that come in, okay, well, I have 2 children and husband, right? So like, okay, well, I want my husband to be my executor, but there's 2 children. Okay, well, one of the children is not good at doing some of these jobs that may be required of an executor, so they can name that person as a alternate executor, and have the person who's more capable of being an executor as an executor, right? So if you didn't have that will, then maybe that you would have died intestate, and then the laws applies in the Wills and Succession Act and the State Administration Act. So those will tell you, okay, who can apply to be a personal representative, and then who is the beneficiary. Again, they are all laid out in the acts, but again, you may not necessarily want those to be the case. So having a will drafted takes care of all those issues. Then other issue is guardianship. I mean, a lot of times I have clients that come in have small kids, underage kids, and they are more concerned about what happens to them if they pass away. So in the will, you can name the guardians, who will be the guardians for these children. Again, just because you have named them in the will does not make them legally guardian. Of course, they'll go to the court step, but that's the instructions from the parents. Hey, this is in our view the best person to take care of our children if something happens to us. Again, if you didn't have that in there, then somebody that you may not have wanted to be the guardian of your children can apply to be the guardian of your children. So that's I think those are a few of the things that is why the will is very important to be done, uh, and rather than just leaving it and passing away intestate.
Yeah, I agree with everything Adil just said. I think really the importance of having a will is that it ensures that your estate is dealt with the way that you want it to be, rather than according to what the legislation says it will be if you don't have a will. And as both of you touched on today, there's two key pieces of legislation that would govern that if you passed away without a will. And they're very formulaic in terms of their approach. So if you don't have a will that appoints somebody to look after your estate, the Estate Administration Act sets out the priority of people who can apply for that role. And as Adil said, the person who has that priority, it could be someone that you don't want doing that for your estate, and someone who potentially may not get along with the beneficiaries as well. So having that control through your will over who you appoint is really important. Likewise, with if you haven't done a will saying who you want your estate to be distributed to, that's all set out, as Adil mentioned, in the intestacy provisions of the Wills and Succession Act. And so it's something called parentelic distribution, a very legalistic term in terms of how that distribution happens. But again, very formulaic in that, it says if you have a spouse, everything goes to that spouse, and so on down the line. So, for example, if you don't have a spouse or children or parents who survive you, but you have siblings who do, everything would go to those siblings, which you again may not want depending on your relationship with those people. So yeah, very important to have a will in place for those reasons. It gives you that certainty around who will look after things and who will everything go to.
Excellent. I think a piece here too that just from my own experience in even just having a will myself, is that it gets you, first of all, having those conversations with people and thinking about who will do this, but it also provides a lot of certainty on the other end. So once you pass away, then people know what you wanted and what's going to happen. They know who's going to apply to be the personal representative. If you have kids, they know that that's the person you wanted to take care of your children. And so, in amongst all the grief and, family dynamics, you've left some sort of certainty for the people that are going to be dealing with this afterwards too. So we say peace of mind for them as well, not just yourself.
Absolutely. I agree, Jess. Having a will does make life a lot easier for the loved ones that you leave behind. And if you don't have a will, it's likely that someone is going to have to make that court application to be appointed as the administrator for the estate. So it's a bit of a burden as well, potentially on the people you leave behind if you don't have a will and they have to go through that process in order to deal with things.
Excellent. Well, thank you both. I'm going to quickly, I know I said I wasn't going to look at the questions, but I took a sneak peek and there's one question I'm going to just address right now. And that's someone's asking the difference between an executor and a personal representative. We're going to use those terms interchangeably. Executor was a term that used to be in the legislation. We still use it, but we also use the term personal representative. So the executive, personal representative, same thing. So hopefully that clears up that question. Okay, question 3. What should people think about before choosing a personal representative? Now, a few things have come out already, but Amy, do you want to elaborate a little bit more and then we'll get to a deal?
Sure. I think the most important thing in selecting a personal representative is that it be someone that you trust, someone that you're confident can handle that role, because it is often very time consuming. It can be complicated and quite a big job. So being sure that the person you're asking, and as Jess mentioned, you should ask before you appoint them. You want to make sure that they're a willing participant, so that there's not a risk or less risk, I guess, that they'll renounce when the time comes, and not be prepared to do it. I think it's also important that you consider the dynamics between your personal representative or executor and the beneficiaries in the will. And that's not to say that they have to be able to cooperate and get along, but it can certainly head off some conflict and potential issues down the road. So that's something to think about. Age is something to consider as well. And that's not to say that you can't appoint someone who's more elderly. A lot of people might want to appoint their parents who are older just because that's who they trust most. I would say that's okay, but if you do that, you want to make sure that you have alternate appointed in case that person is unable to act or dies before you. Often better to plan with people who are maybe close in age to you, or perhaps younger as well, if that seems appropriate. And then the other thing I would mention, which sometimes people don't think about, is where your personal representative lives. So it's ideal to name someone in Alberta, mostly for logistic reasons, but you can appoint people who live in other provinces. That's not a problem. It might just be a bit more difficult for them to carry out that role. There's also a chance that they might have to pay an insurance bond, not to confuse things, but sometimes for out of province executors, the court will require that they have to pay a bond or some other form of security if they're not resident in Alberta while they're acting as the personal representative. And then of course, we usually recommend against appointing an executor who's a non-resident of Canada for income tax purposes. And the reason for that is an estate is really a form of trust. And as a trust, it can have a residency. And so if you appoint somebody who isn't a tax-paying resident of Canada as your executor, that can potentially have income tax consequences depending on jurisdictional issues. So things to keep in mind when you're selecting that person.
So I think Amy touched on almost everything that you would consider. Just a few things to add. Provide a little bit more details on what you should consider before choosing a personal representative, and that would be is the most important thing, in my opinion, would be is if they understand you, if they know you, if they know you good, right? A lot of times people, if they leave things, let's say their children are their executors, but they haven't lived with their parents or with you for a while, then they may not know, okay, what accounts you have, what assets you have, and they may not be up to date on that. So maybe you want to get somebody as a personal representative who knows about all those things, right? Who's close to you. That's not to say that you cannot have somebody that is not as close, but that would be the preference. As Amy also mentioned that you want somebody who's close to you. I've seen clients that have people named outside of Edmonton. They live in the client is in Edmonton, tester is in Edmonton, but the executor may be in Calgary or maybe closer to BC borders, right? That's good, but then you also have to look at, do they have the means to travel back and forth to act as a personal representative, right? So they may not have the means to travel back and forth to do the applications and look after your state. Again, I always advise my clients to choosing somebody who's outside the country as an executor. Another big thing is, like she mentioned, is they need to get along with your beneficiaries, or at least at that time you need to have understanding of how well they get along with beneficiaries. I've seen executives that are, again, the family members, but they don't get along with beneficiaries, and they're always like on each other's throws. Hey, you didn't tell me this. What's going on with the probate process? You're not doing this right. All of those things. So the infighting in that case can be very detrimental towards how the probate takes place and how the assets are divided. So that's a few of the things just wanted to mention. But again, Amy touched based on all the most important things that you need to consider when choosing a personal representative.
Perfect. Well, thank you both for sharing on that. I had a brief thought and now it's left my brain. So if it comes back to me, I'll throw it out there. But your personal representative too. I was going to mention something that's, we've talked about someone being close to you, which is important, and understanding what your estate is, what comprises your estate. And one of the things that you can do, it's not always comfortable. I know it's not easy to talk about death sometimes. It's not easy to share that. But if it's someone that you trust and you're close with, you can talk with them beforehand too, just so you know, this is where my accounts are. This is some of the property that we've got, or make a list and have it included with your will. Here's where to start. Here's where to start looking for all my money. It's hidden here. Those are usually the things that are the hardest to find if you've got money tucked away in accounts and investments and nobody knows about them. So a couple of things you can also talk about is if you can talk to that person, if you're comfortable talking to that person beforehand, as well, and just get some of that piece out there. Okay, I'm going to move on to question number 4 because this is a big one. Some people think making a will is only for older people. Is this true? I'll start with you, Adil.
Yes, that's a good question, and I know there's misconceptions out there. Um, in my opinion, it couldn't be any more false. I mean, it should be the other way around. Uh, the reason being is that I mean, this just came to my mind is, let's say, for older people, they already have, if they had kids, they're already grown up, so they don't have to take care of, hey, who's going to be their guardian, and they don't have to look after, hey, they're not as worried about, hey, are they being taken care of in terms of financially, right? But younger people, they might have younger kids. Now that makes the will more important, because in the will they'll have to they can choose who the guardian needs to be. And if they can, I mean, if their children are under 18, they have to form trust, and who the trustee will be to make sure that as long as the children are underage, and again they can set the date, that the trustees are reliable and they are trustworthy to make sure that the underage children are taken care of in terms of financially, and as a guardian, so where they can stay, who will. So in that case, will is important for everyone, and everyone, in my opinion, should have a will as soon as they are turned 18, or at least they have some assets, or when they start getting into starting their family, right? So all I mean, I think misconception comes because people are like, okay, well, they're old, they're nearing end of their life, so maybe they should write a will to say who gets what. But again, that's good. But again, if you are old, that's another thing you have to consider. You might not have capacity at that time, right? So those are big concerns. Maybe you're suffering with dementia or Alzheimer's, or you lack some kind of capacity, then that makes it difficult to make a will at that time, and you never know when that's going to happen. So I've seen clients where, and they have come, hey, I need to make a will. Then you can just few minutes of conversation with them, hey, they don't have the capacity, or they at this time they don't have the capacity to make a will. And so that's important to consider. So I would recommend everyone to have a will as soon as they have some asset and they start their family. If anything, before that, that's always recommended. But that's the starting point. I mean, if you're starting a family, if you have kids, and you have some assets, you need to make a will, or you should make a will, I should say.
Amy?
Yeah, I think Adil's really covered it all. I agree completely. Wills aren't only for older people. Really, any adult should and can and should make a will. And I think, it touches maybe on a question that's coming up about misconceptions people have too. But some people think, well, I don't really have much by way of assets, especially for younger people when they're just kind of starting out in their jobs, or maybe they're in school, and they think, so I really don't need a will because I don't really have anything. And that's not really true, because inevitably there's probably going to be something in your estate that will need to be dealt with, and that someone will need to be appointed to deal with that. So having a will, at the very least, even if you don't have many assets to distribute, it would appoint somebody to look after things for you, and just, as we talked about before, makes things a lot easier for the people that you leave behind.
As I always say, we you could get hit by a bus tomorrow, and so none of us really knows our own fate, right? And so to say, oh, that's, I won't worry about that till I'm older because that's when it matters. Well, that's, there's cases of young people then that need wills, like you said, for children, to deal with, to take care of their children and whatnot. The one thing that was running through my mind when you said, as a young person who they don't think they have much. I mean, the one thing that comes to mind is canceling your social media accounts. Like, can anyone do that? Or do is it good to have someone appointed who then has the authority to do some of that as well?
Yeah, that was one. Sorry. Yeah, that also came to my mind. Is like, okay, well, younger generation is very active on social media, like Instagram, Facebook pages, and they have a lot, and they are proud of those accounts. So you can name somebody who can take over their account, I mean, in the will. So that's something, if you don't have any accounts in terms of financially. So there's always something.
So influencers, if you need someone to take over your business, then you should probably have that in your will.
Yeah.
Okay, I'm going to move on to the next question quickly, because we are running short of time and I see we have lots of questions. So I want to make sure we can get to them. So what other misconceptions do people have about making wills? We've covered a few of them, but Amy, is there any other ones you want to add?
Sure. Maybe I'll just touch on a couple really quickly. I've had a lot of people ask, if I don't have a will, does my estate go to the government? A lot of people seem to have that misconception that if you don't have a will, everything you own goes to the government, which is actually not true. So it's not a reason not to get a will, but that's just a misconception I think is out there about how that works. I think one misconception that I was going to speak to, but I think you covered, Jess, is around funeral directions in the will. I agree with you completely that it's fine to have it in the will, but I always tell clients, don't rely on that alone, because you just don't know when that's going to be read. The other thing is, a lot of people don't know that funeral directions are the only thing in a will that isn't actually binding on your executor. And so having that conversation with your executor beforehand about what you want is also really important, because they might be more inclined to make sure they follow your wishes if you've had that face-to-face talk with them, as opposed to leaving it in the will. And then I think the other misconception that a lot of people have is that making a will is really complicated, really time consuming, and it can be those things, but most of the time it won't be. There are certainly complicated estates out there, but I think a lot of people feel daunted by making a will because of the time it will require and the thought it will be given. But once you start the process, you'll probably find that you actually have a lot of peace of mind after completing it, and that the amount of work that goes into it might not be as much as you think it's going to be when you're heading into that process.
Excellent. Thank you. Adil?
No, I think she covered everything that on this question.
And we've talked a lot about misconceptions throughout time. So I just wanted to have this question there in case we kind of a catch-all. The next question is a big one as well, and that's what can people do if they are concerned their will not be followed, or that a personal representative is not following someone else's will? I know this is a bit of a loaded question. We're running short on time, so I'm going to hand it over to you, Adil.
So yeah, just a few points to on this. Again, that's where you have to decide and think about who your executors needs to be, right? If you already have concerns about them, well, then likely their other issues will come up during the process of probate, right? Another so what I always tell people is that, and that's something that's good thing to consider, is that a lot of times the executors and the beneficiaries are the same people, right? Maybe the orders might be changed, but if your executor is somebody that has the most interest, that has the most, they're getting the most from the state, then you should, in my opinion, name them first. If you trust them, I mean, why would you give them something if you don't trust them, right? So because they have the most, in that case, they have the most stake in making sure that everything goes smoothly, because they have the most to gain from it. The other thing is, what if the personal representatives are not following the will of somebody, right? That's there's a the You can always ask them, because you can always get them involved. Hey, tell me what's going on. A lot of times they have lawyers that are involved in probate process. You can talk directly to the lawyers, because they are supposed to give you the notices, if you're a residuary beneficiary. And again, if they do not, then you always have the option of going to the court system and asking the court to help you understand what's going on with the state. And in some cases, again, it doesn't happen very often, but it does happen that if the court thinks that, hey, the executor is not doing the job as he or she should be, then they can appoint a new executor. Again, there's always options out there, but you don't want to be there. So again, one option would be is you can name uh, two or three people as to act as joint personal representative executors, so they can work together. But again, you have to consider very carefully if they get along. If they don't get along, well, they're not going to accomplish much working together. So
Perfect. Amy?
I think Adil really covered it all. I think the only thing I would add, in terms of what you can do to make sure, to the extent you can, that your will is followed, if you have concerns about that, is you can include that kind of language in the will, that your personal representative who you're appointing, that they really have absolute discretion and authority over these things, and that you can clearly express that's binding on your beneficiaries. I've seen that kind of language in wills before, where people are clearly concerned about perhaps adult children fighting over the estate. So that's one way. It's not ironclad in the sense that, reading that won't necessarily stop people from fighting, but making your intentions really clear in the will about that, that you want people to get along, and you're trusting your executor, giving them that authority to do what they need to do. It can only help, I think, rather than hurt, to have that kind of clear language.
Perfect. So yeah, I think that, as both Adil and Amy have shared, and we've talked about, personal representatives have legal duties. And so if they are not following those legal duties, there is recourse available. So I just, in case someone was wondering, personal representative, they don't just get to float out there and do their own thing. They do have specific legal duties set out in legislation. So okay, we're going to go to our last question. What other resources are available for people wanting to learn more about making a will? Amy?
I think honestly, things like this are really helpful, and are out there. So things like CPLEA's resources are a great place to look. There's a lot of information on the internet, and a lot of it is very good information, but you just need to be careful, I think, about the source. So looking at resources like this, other legal clinics in Alberta have similar things. For example, Edmonton Community Legal Centre has resources and does webinars, I believe, from time to time. Another good place, actually, for just very basic information is the Government of Alberta website on wills, where it lays out some of the terminology and some of the basics basics about wills. And of course, I would say you can always call a lawyer. Not all lawyers will provide free consults, but a lot will, at least to initially guide you through some of these questions. So, if you're really in doubt, I would say don't hesitate to call a wills and estates lawyer to broach some of those questions that you might have as well.
Yeah, I think Amy touched based on all the resources that I could think of, like, again, Center for Public Legal Education Alberta. They have really good resources and booklets on this, on how to make a will, what are the requirements and what to consider. So that's a good resource right there. ECLC, like Edmonton Community Legal Center, as Amy mentioned, is very good resource. I do volunteer for them too. So they have, they can advise, they can have you speak to a lawyer on wills, and they can even have a lawyer help you make a will if that's the case. And a lot of government agencies or the government themselves have these smaller resources on their websites that you can look into. And like she mentioned, like Amy mentioned, a lot of lawyers like myself, when the clients call, I give them, I answer all the questions they may have on the phone. It doesn't hurt to answer people's questions. So there's a lot of lawyers that will do that and give you free consultation. So that's something that you can approach if you are thinking of making a will, or how to approach the process.
Excellent. Thank you both. You've both mentioned our resources, and here are covers of two of our booklets that are most topical. So Making a Will and Being a Personal Representative. Those are available for free online. We've posted the link to them in the chat, so you can download those, print those. If you're an agency and you want to be distributing those to people that you work with, you can also order those booklets free from us, and we'll send you hard copies that you can keep in your offices and distribute as you see fit. I'm also going to just, they're on our website. If you go to CPLEA.ca and look for legal info, planning for the future, you'll find all of our planning for the future resources there. Oaknet.ca is one of our websites dedicated to law for older adults. And so Oaknet.ca also has information about estate planning that mimics the information in our booklets as well. But I'm rushing because I really want to get to the questions. A few upcoming webinars. As I mentioned, we're going to be talking about personal directives and powers of attorney on February 16th. You can register for that webinar the same way you did for this one. And then we'll be finishing off with Adult Guardianship and Trusteeship Act on March 2nd. And in the middle, in case you're interested, we are doing a piece on legal advice versus legal info, which is especially topical if you work in a service, if you're a service provider or work in an agency that's assisting people with legal problems. So 3 upcoming webinars. Go to CPLEA.ca/workshops to find the registration links. Okay. We're going to post a link to an evaluation in the chat. We really appreciate if you could take a few seconds to fill that out. But I am going to go directly to the questions because we are running out of time. Adil or Amy, if one of you has to leave at 11, please do. I will stay on to get through some of the questions, and you're welcome to as well, because I do want to get through as many as we can. So I'm going to start at the top here. Are there any advantages or disadvantages to having your adult children as joint ownership of residential property or bank accounts? That's a big one. Who wants to start? Amy, I see you smiling. Do you want to start on that one?
I can jump in. That is a big question and a common one. I would say there can certainly be advantages to that. So we talked just a little bit about probate, and Jess had mentioned in the presentation how property that you hold jointly, so when you're talking about like a house, let's say, when you own that as a joint tenant, it passes outside of your estate. So some people will, they want to use that joint ownership of a house, for example, to simplify things and get around probate. Some people will want to do the same thing on bank accounts for the same reason, to create that, we call it a right of survivorship, that when you pass away, that asset then goes to the joint holder, rather than you needing to apply for grant of probate to deal with those assets. The caution I would give is that there can be conflicts that arise, especially when you're naming children, adult children, jointly on assets. If you're contemplating doing that, my suggestion is you need to be very careful about how that's structured to make it clear what your intentions are, whether your intention actually is that asset is to be held for your benefit and the benefit of your estate, or whether you're actually intending it to go to that child. Because if that's not clear, that can lead to conflicts after you pass away, and legal disputes that end up in court. So I'll try to keep it brief. It is a big question. I hope I answered that. There are advantages, but there are potential disadvantages as well. I don't know if Adil would have something to add there.
Yeah, just one quick thing to add. Amy covered most of them. Just one thing you have to consider is that, let's say if you're putting somebody, an adult child, on as a joint tenant on your property, and you're not at the point that, hey, depending on what condition you have, and you never know when you're going to pass away. But again, if you add them, then if you change your mind in terms of, hey, I need to sell this property and buy something else, well, now you have to get their signatures on the transfer of land. You can't just sign yourself, which you could have if you were just yourself on the title, right? So those are some practical things to consider when you're deciding how to approach this, right? And a lot of times people do this when they're like end of their life. Hey, my child is going to get these things anyway. I want to avoid as much as possible going through the probate process and just sitting there waiting for the probate. So, but those are practical things you have to consider, and have to choose your time when you do these things. I think that's very important.
Perfect. Okay. Thank you. We also have some of that answer that question. If you want more, the same points that Amy and Adil made, we reference in our Making a Will booklet as well. So if you want something to go back to afterwards, those points are referenced there. Okay. There are stores who sell will kits. How valid are those in court? Maybe I'll just get one of you to answer that. Who, does one of you want to take that question?
I guess I can take that. Yes, those kits are there, but again, those are made for one size fits all. Not everybody will have the same thing, and a lot of those kits, if you buy them from the stores, like those physical, and then you write them with hand, then that could cause some complications. Like, okay, well, who wrote what, right? Anybody can add something, and sometimes people cross off. Um, then they might not be as people can add something that they shouldn't have added, or maybe some other person other than yourself can add things with a pen. Who would know who wrote what, again, unless somebody can read your handwriting. If you go to, like, let's say when I dropped or lawyers dropped, you won't see anything other than your signatures that's in pen. Everything else, including the dates, are in typewritten. So, and then again, the wills, like I said, the kids have everything they can possibly think of in one kit, and you have to cross them off. Um, and sometimes people don't know, like, you need two witnesses to sign. It's good practice to initial. A lot of them don't have the NC8 forms, right? So again, if you find like a random friends to act as your witnesses, and when the time comes for probate after you pass away, well, who's going to find those friends to sign as a witness to your affidavit NC8? So, and again, then you don't have a lawyer. If you don't have a lawyer, you just have a kid, then they can tell you, okay, this is what you need to consider, this is how you should name those people. Everything that we discussed today isn't there for you. It's just a piece of paper that you can fill out as you think should be. So they're resources, but I don't advise my clients to use those.
If I can add just one thing really quickly, I know we have limited time. The other thing, I agree with everything Adil said, and the other thing that people don't realize is that wills and estates law is provincial and territorial. It's not federal, and some of those will kits will be called Canadian will kit, but they're not tailored at all to the province of Alberta and the laws here. So if you're using a will kit, you need to be very careful about that, because the laws do differ between provinces on wills.
Perfect. Thank you for that. Okay, I have a question here. Although I understand the advantage of using a lawyer to make a will, I work with low-income seniors who cannot afford a lawyer. What is recommended in terms of preparing a will? We've talked a little bit about that, some of the services available. I'm going to leave it there. If this person has any further questions, please feel free to reach out to us. We mentioned some of the legal clinics in Alberta that can help with that. I know in October, I think it's usually in October, there's like a wills week. So there can be some, some dedicated clinic time as well to help with wills. So I'll leave that one there. I'm also going to quickly answer the next one. Can you elaborate on power of attorney and if the green sleeve from AHS would suffice or another document is needed? I'm going to tell that person if you can come back in 2 weeks, we'll be talking about personal directives and powers of attorney. So more so the decision making before you pass away. So, personal directives powers of attorneys and green sleeves do not work after you pass away, if that was the question. So if you want to learn more about those documents, though, come back in 2 weeks. Does the will have to be notarized to make it a legal document? How do I say, Amy?
Sure, I can answer that quickly. So the quick answer is no, it doesn't need to be notarized. Depending on whether it's a typewritten will or a holographic will, which, as Jess mentioned, is a will in handwriting or the writing of the person making it. There's different requirements in the legislation for the will to be valid. It being notarized is not one of them. So if it's a will that's typed up, typically what you would need is for it to be witnessed by 2 people. And those witnesses and the person making the will should also initial every page of the will except for the signature page in order to make sure the initialing isn't a validity requirement, but it's good practice so that there can be no dispute about pages being slipped into the will that change what it says after it's been signed. But as Adil has mentioned a couple of times, there is something called an NC8 affidavit of witness. And that's a form that the court requires when you apply for probate, which is sworn by one of the witnesses saying, yes, I saw this person sign their will, I was there. The court needs that when you apply for probate. If you don't have it, as Adil mentioned, you can end up on a real wild goose chase trying to find at least one of the witnesses to swear that. Otherwise, you have to kind of, on a hope and a prayer, ask the court to accept it without it. So that piece of it the affidavit of witness does need to be commissioned, but is just an add-on to the will.
Perfect. Okay, Adil, do you want to take the next one? Where did my question disappear to? What is the typical cost range for a lawyer to set up a straightforward will?
Well, that depends on the lawyers, right? Again, there's a lot of lawyers that do them for a lot less than other lawyers. Like if you go to ECLC, they have resources. If you have a low-income families or low-income individuals, then they can do it for a lot less. So it depends on the lawyers. There's no set amount.
Perfect. And yeah, that's a lawyer's favorite answer, but it's actually true. It really does depend. And I will say this too, having worked in this area before, lots of lawyers will offer kind of package deals for a will, power of attorney, and personal directive. So they will do all at the same time. And sometimes if you're doing it with your spouse, then there's recognition that those, are kind of mirror documents. So, but feel free to reach out to lawyers and ask them how much it's going to cost to do this. Okay, is there a will I wrote when kids were younger still in effect now that they are 26 years old? I'll answer this quickly, just say we did talk about that a little bit. Yes, as long as it still expresses your intentions. Is that fair to say?
Yes.
Yeah.
I would agree. Yeah.
And in some of those pieces that say, these are the guardians of my kids. Well, obviously, if your kids are older, we just ignore that piece because it no longer applies, right? But it doesn't mean that your will is not invalid. Okay, if there's time, can you please explain probate? That's a big one. Before I get one of you to answer that, I will just say we do have a resource specifically on getting a grant of probate or administration. We have an entire booklet dedicated to that. So that does explain it a little bit more. But if one of you guys want to give like the high level view of what probate is.
I'm happy to do that. Probate, what that means is it's the process by which the will is given to the court, and a judge reviews it, as well as application forms that need to be prepared to go with the will. And after reviewing all of that, the judge will sign off or not on a grant of probate, saying, yes, everything appears to be in order here. I'm approving the will. And once that's done, what's issued is called a grant of probate. And what the effect of that really is it then allows the executor or the personal representative of the estate to rely on that grant. For example, the bank might say, we need a grant of probate to be confident that we can allow you to deal with these assets. So that's what the grant of probate is. It's really the court's approval of the will that signals that the executor has the authority to do what they need to do, and that the will can be relied on by financial institutions and others.
Perfect. Okay, and one more for you, Adil. Are video wills valid?
Video wills. I'm not sure what that means. Maybe they're asking about virtual signing of the wills.
I think, or maybe a recording, like recording yourself expressing your wishes in a video.
No, that's not a way of. That's not one of the ways on how you can make a will. Now, I guess maybe the other question would be is that's where I can answer the virtual will. Because of COVID, the legislation was changed a few years ago, last year, that you can sign those wills and have the wills signed on virtually if there's lawyer is involved. So the lawyer has to be involved, and so that's one of the flexibilities because of COVID. So it makes more gives me flexibility to people that are maybe in remote location, or otherwise they are too old, or have some limitation that they cannot come to a lawyer. They can do so virtually.
And I'm going to stress that again. It's only if you're working with a lawyer. So if you have a will and want it witnessed by two people, you can't all join a Zoom call and say it's good to go. It's only if you're working with a lawyer on that. Okay, I think we've covered all the questions. We ran 10 minutes over, 12 minutes over, but thank you both so much for staying on to answer those questions. And like I said, we'll be back in 2 weeks to talk about personal directives and powers of attorney. And yeah, I'm going to leave it there. But again, huge thanks, Adil and Amy, for your insight and perspectives. And have a great rest of your Wednesday, everyone. Thank you.
Thank you for having me. Thank you.